Hi everybody. Today's Facts in 5 video is all about the impact of the Dobbs case that was recently handed down by the Supreme Court and its potential impact on the rights of same-sex couples. So while the Dobbs case, as almost everybody has heard, had the impact of overturning Roe v. Wade, so taking away guaranteed right to access to abortion for women, what was also interesting to note, or actually what was more concerning to note, that in a concurring opinion on the Dobbs case, Justice Clarence Thomas also indicated that, or made clear that the grounds on which we had initially granted the right to access to abortion under the Roe case are the same grounds under which the Supreme Court guaranteed the right of same-sex couples to be married, and had indicated we should reconsider those cases to determine if those cases were also decided appropriately. So indicating that if a case came to the Supreme Court questioning whether, again, there is this constitutional right to same-sex marriage, that might ultimately be overturned as well. So this has a lot of same-sex couples really worried, and rightfully so. Just because even though you're deemed to be legally married now, a decision that comes out of the Supreme Court case could potentially invalidate what is now a legal marriage, or it could take away the right altogether for couples to get married in the future. So again, a really concerning development. And it has, again, same-sex couples worried about what can we do, what can I do to guarantee my spouse or my partner these rights that I want them to have. And from an estate planning context, it's as simple as getting some very important documents in place, some very basic estate planning documents in place. And the big documents that you should consider implementing if you are in a same-sex couple is a will, a power of attorney, a healthcare directive, and a HIPAA waiver. Just because every state has its own default rules about who is allowed to inherit your assets, who will become the guardian of a minor child if there is no surviving biological parent or legal guardian, who is allowed to make medical decisions for you if you're not able to do so for yourself. So there's always going to be these default rules out there, but you can override all of those default rules. So even if the state or even if the federal government takes away, again, the guaranteed right to inherit or the guaranteed right to become a guardian or make decisions for you, you can still, again, override those rules by having these documents in place. So with the will, again, the number one thing that most people think about with wills is you get to designate who's going to receive your assets when you pass away. So even if you and your spouse aren't deemed to be married at the time, again, due to any ruling that might come down for the Supreme Court, your will can still state that that's the person who's going to inherit your assets when you pass away. So you're going to guarantee, again, that you get to decide where your assets are going to go after you pass. It should also be noted that not all of your assets are going to pass under your will too. Some assets are going to pass under a beneficiary designation. So it's also important not only to get a will in place, but to also update any beneficiary designations on retirement accounts or life insurance policies or any other type of financial accounts to, again, name your spouse or name your partner as the primary beneficiary of those accounts, because that's also going to ensure that they're going to be able to inherit those assets as well. So definitely consider getting a will, again, because that's going to direct who's going to receive your assets after you pass away. Number two, again, if you have a minor child with your spouse and you're not the biological parent, you're not necessarily going to be the legal guardian, again, or able to become the legal guardian of the child after the biological parent passes away unless you have certain legal documentation in place. So you can go the adoption route. Clearly, that's always going to ensure that you're the legal guardian and legal parent of your child. But you can also do a will that states that if you pass away, and let's say you are the biological parent or you are the current legal guardian of the child, that you get to designate who the guardian is going to be for that child after you pass away. So you can designate your spouse or you can designate your partner, again, to guarantee that they're going to be the person that's going to be taking care of that minor child if something should happen to you. So that's in terms of assets under a will, or again, appointing guardianship for minor children. But also important to note that there is, at least under Connecticut law, there is no default decision maker for you if you're not able to make medical decisions for yourself or make financial decisions. That's actually true whether you're married or not, whether you're a same-sex couple or not. So it's always important to make sure you have documents like a power of attorney, like a healthcare directive in place, to make sure you're choosing who that person is going to be that's going to make decisions for you if you're not able to make decisions for yourself. Also really important to make sure you have a HIPAA waiver in place, because a HIPAA waiver is going to be, essentially, it's a list of individuals that are going to be able to communicate directly with your doctors. So if you're concerned about your spouse or your partner not being able to gain access to your medical information and talk to your doctor if something were to happen to you, very important to have a HIPAA waiver in place. So again, just with the recent Dobbs ruling, it's so important to get your legal house in order, get these documents implemented, just to ensure that really the wishes that you have are actually going to be carried out.